It's Nolan. Now, before we get started, make sure y'all hitting that like button. Make sure y'all sharing it on your respective platforms. Let somebody know what we're doing today. Now, let's get into the show. There's a reason rappers can turn any story into a hit track. Just like there's a reason Morgan & Morgan is America's largest injury law firm with over 1,000 attorneys and more than 100 offices nationwide. If you've been seriously injured in an accident, your case could be worth millions. But the truth is, a lot of people either don't file at all or get taken advantage of by insurance companies. When you hire Morgan & Morgan, it's like hiring a legal army that has your back. If you're injured because of someone else's negligence, you deserve to be paid. No shortcuts, no lowball offers. In fact, they've secured some major verdicts in the past. For example, in Florida, they got a victim who was in a life-altering car crash, $12 million. 34 times the highest insurance offer. They got another victim in Philadelphia, $26 million. 40 times the highest insurance offer. Not all law firms are created equal. Morgan & Morgan is the biggest for a reason. They will fight for the biggest award possible and have won a lot. So if you're ever injured, you can check out Morgan & Morgan. Their fee is free unless you win. That's right, no upfront costs. They only get paid if you get paid. You can start your claim now by clicking the link in the description or by scanning the QR code on screen from your phone's camera. Again, if you find yourself injured, you can check out Morgan & Morgan. Don't say I never told you nothing, man. What's going on, beautiful people? It's the kid J Nolan here. Welcome back to another episode of Inside the Industry, your number one source for music, entertainment, commentary, and breakdowns. Hope everybody's doing well out there. Y'all know we just came to y'all yesterday giving y'all some updates in this whole Megan Milagro situation before the trial jumped off. Today is officially the first day of trial between Megan Thee Stallion and Milagro in Florida. Both of them are in attendance in the courtroom. As a matter of fact, Milagro is on the stand right now being questioned by Megan's lawyer. So things have taken off pretty swiftly. The jury has been chosen. Opening statements have been given, and Milagro is literally on the stand already being questioned. Okay? Now, unfortunately, there's not a lot of feet on the ground out there at the courthouse. Megan Cuniff is out there. She's given updates here and there, but she's not as swift as like Inner City Press. I don't know what it is about Inner City Press with how he gets his content up to Twitter when he's at a trial. I don't know if he's literally recording the room and it translates into tweets, or if he's just like tweeting his life away while he's in the courtroom. But nobody's fucking with him when it comes to live trial coverage when cameras and footage are not permitted, right? So right now, she's the only source we have. I think everybody else that's down there is either just, just doing regular investigative journalism, or they're probably planning on doing content later to talk about all the happenings of the day. So we're not going to get up to the minute updates. However, we do know that Tory Lanez has already been punished. As a matter of fact, he's being held in contempt due to his failing to comply in terms of the depositions in this case. They attempted to depose Tory Lanez 3 separate times leading up to today. I believe the final attempt was at the top of this month, and he was uncooperative in all 3 cases. Okay? As a matter of fact, the last 2 times he had his attorney present, she was instructing him. However, due to her instruction, she was not actually coaching him on answering the questions or like breaking things down for him. He had emotional outbursts. They say he even stormed out of this last deposition. All right. So because of that, he's now been fined $20,000, and his lawyer is being paid $5,000 for her contribution to the contempt. All right. We're going to get to the paperwork and go through this whole thing. But again, I can only give y'all the information that is available to me. I just can't. If I was in a different position, I probably would have gone, but we not. All right. We here. So here we have the official order of contempt from the judge. All right. And of course, this is again for the Megan Pete, aka Megan Thee Stallion, versus Milagro Cooper case. But this order of contempt is for Tory Lanez. This matter is before the court upon plaintiff's request that non-party witness Daystar Peterson and his lawyer Crystal Morgan be held in contempt of court for their conduct during a deposition held on November 14th. Damn, this was just Friday. Shit. The underlying facts involved in this dispute and the two previous attempts at taking Mr. Peterson's deposition in this matter are recounted in the court's previous order denying motion for protective order and or to quash subpoena. The undersigned was personally present at both the second and this third attempt to depose Mr. Peterson. As the court in R.E. Stephan noted, the task of imposing sanctions on litigants and their attorneys is one of the most distasteful tasks of any judge. Notwithstanding, when the time arrives when this court must perform such a task, it is clearly executed to ensure that the court's business is properly conducted and to preserve the respect for the judicial system and for the court as a whole. A court's power to use a citation of civil contempt to compel compliance with its directives comes both from its inherent authority. Okay? Courts have embraced an inherent contempt authority as a power necessary to the exercise of all others, citations and quotation marks omitted. The court's power to enforce compliance with its lawful orders is inherent and from the Federal Rules of Civil Procedure, C-45G, allowing a court to hold in contempt a person who, having been served, fails without adequate excuse to obey the subpoena or an order related to it. Here, for the reasons that follow, the undersigned finds Mr. Peterson and his attorney in contempt of court and must impose sanctions. Okay, so that's also going to go on his attorney's record, being hit with these sanctions and being held in contempt. Because Mr. Peterson is incarcerated, taking his deposition required an order of the court pursuant to Federal Rule of Civil 30A-2B. Chief Judge Altanega entered such an order in this case. Mr. Peterson's first attempted deposition lasted approximately 44 minutes because Mr. Peterson behaved inappropriately and personally insulted the attorney taking the deposition. Mr. Peterson's then lawyer, who at the time also represented defendant Miss Cooper in this matter, did not oppose sanctioning him for this conduct. So he was sanctioned the first time out. That's from Unite the People when they were representing him. Michael Hayden, counsel for defendant and appellant counsel for witness Daystar Peterson, noting that Mr. Hayden did not object a motion sanctioning Mr. Peterson's conduct. I wonder where the relationship with Tory and Unite the People stands today also. Mr. Peterson was sanctioned by Chief Judge Altanega in order to sit for a second deposition to be supervised by the undersigned magistrate judge. During the second attempted deposition of Mr. Peterson, which I supervised, Mr. Peterson questioned what the consequences for failing to comply with his deposition obligations would be. Okay, so the judge, I believe this is Judge Lisette Reed, she said she was personally there. Okay, she said she informed him. Sanctions could range from monetary fees through days in prison under the court's contempt authority. Mr. Peterson responded that he got jail for 10 years right now. You can do whatever you'd like to do. Okay, so he says, I'm not going nowhere out of this jail, so fuck it, just send me back. He also indicated that he was not concerned with monetary sanctions. He didn't care about what the price may be. Mr. Peterson sought a motion for protective order in California, where he is incarcerated, to bar the deposition from taking place, arguing that his criminal conviction was on appeal and raised concerns that he could be asked questions regarding his criminal case. The California federal court in which Mr. Peterson's motion for protective order was filed held a hearing on the matter and denied the motion. The court also transferred the issue back to this district for further proceedings. After a full hearing on the matter, the undersigned denied the motion for protective order and ordered Mr. Peterson to sit for a third continued deposition, and since then, his appeal has also been denied. Therefore, he will continue to sit for the remainder of his 10 years, which I believe he's already served, 3? The third continued deposition occurred on November 14th, 2025. Before starting, Mr. Peterson again asked what the sanction for not answering questions would be. When told his behavior could result in contempt of court and sanctions consisting of fines and additional jail time, Mr. Peterson then said, "Whatever the fines are, I'll pay them. I'm a millionaire. I don't care." Okay? So he says, fuck the fines. Mr. Peterson also told plaintiff's counsel to calm down and relax. Mr. Peterson then called plaintiff's counsel a liar. Plaintiff's attorney was unable to ask more than 2 questions before Mr. Peterson stormed out of the room and sought to end the deposition, stating that he had not been shown in advance all the exhibits plaintiff's counsel intended to use during the deposition. After some time and discussion with his lawyer, Mr. Peterson returned to the room. After the third question, Mr. Peterson got upset and told plaintiff's counsel that she came in here hot and failed. For the people that are backing Tory, this is the person that you're backing. Sounds like the actions of an innocent man to me. Right. Contrary to Mr. Peterson's accusation, plaintiff's counsel maintained her composure at all times. Mr. Peterson then again abruptly exited, this time making derogatory comments. Specifically, while exiting, Mr. Peterson lodged multiple expletives towards plaintiff's lawyer, D. Peterson. Towards plaintiff's lawyer. He then refused to return to the deposition. All right, so he walked out this time and refused to come back. Mr. Peterson's counsel also obstructed the deposition. Ms. Morgan, an attorney, can be sanctioned for failing to comply with the requirements of Rule 30 and failing to uphold professional standards. Throughout the attempted deposition, Ms. Morgan objected to the relevance of questions regarding communications between Mr. Peterson and the defendant, questions that were clearly relevant to the proceeding. She engaged in lengthy speaking objections, coaching the witness, and continued to do so after she was requested to stop. Even after her objections were ruled upon, she did not once instruct her client to answer plaintiff's questions. She in fact complained that she had difficulty reaching Mr. Peterson and could not meet with him in person to prepare him for his deposition because he was in prison. Yet both the stenographer and a representative from plaintiff's attorney law firm were present in the room with Mr. Peterson during the deposition. Plaintiff's representative in fact showed Mr. Peterson plaintiff's deposition exhibits. Further, with respect to plaintiff's deposition exhibits, Ms. Morgan complained she had not received them despite having received them by email from plaintiff's counsel. So she's also making a mockery of this process as a barred attorney. I'm sure this will bode well for your career. Her conduct served to reinforce and sought to excuse Mr. Peterson's contentious behavior rather than ensure compliance with court orders. Sanctioning attorney and imposing restrictions on redeposition of third party where attorney's questioning crossed the line into improper, abusive advocacy. Imposing sanctions after witness had been unsuccessfully deposed 3 times. Counsel, interrupted the witness and would not let him complete his answer and provide his explanation. His tone of voice can be described as yelling. Many of his questions were improper. So these are just references to similar situations in the court. The 3 questions plaintiff's counsel asked during the deposition were: 1, how he first came to know defendant Cooper. So these are the questions that he was asked in the deposition. Question number 2, whether Mr. Peterson communicated with defendant Cooper, and 3, whether he sent Ms. Cooper Instagram direct messages or text messages. So these are the 3 questions he was asked, and he said they came in hot. Okay? And of course, the exhibits already show the communications between himself and Milagro. So being put on notice that they already had the answer to your question, we just need you to confirm it. It rubbed him the wrong way. Okay? It was like rubbing alcohol on his forehead. During the deposition, plaintiff moved for an adverse inference based on Mr. Peterson's refusal to answer the 3 questions. Namely, she requested that the jury be instructed at trial that Mr. Peterson's answer to these 3 questions would have been favorable to plaintiff and therefore unfavorable to defendant Cooper. What's the relevance of that? It's just a question. You either answer it or you don't, but the evidence is already there. The undersigned initially denied this motion as the inference requested would necessarily alter the rights of defendant Cooper, who was not involved in the instant deposition. Although not addressed yet by the 11th Circuit, other courts have allowed the finding of an adverse inference against a party based on a non-party witness invocation of the Fifth Amendment privilege during a deposition based on a close relationship between the party and the witness. To draw an adverse inference based on a non-party witness invocation of the Fifth Amendment, the court must evaluate the following factors. 1, the nature of the relevant relationships. 2, the degree of control of the party over the non-party witness. 3, the compatibility of the interests of the party and the non-party witness in the outcome of this litigation. And 4, the role of the non-party witness in the litigation. Whether Mr. Peterson actually invoked his Fifth Amendment privilege or not, the undersigned finds the factors found to be relevant in the instant inquiry. While the first, third, and fourth factors weigh heavily in favor of granting an adverse inference, the second factor, defendant Cooper's control over Mr. Peterson, is not so well defined. Indeed, in Bank and Lighthouse, it involved situations where the non-party was a direct employee of the party to the litigation and where control was more explicitly defined. I don't recall any control of Milagro over Tory. It seemed to be the exact opposite, if anything, as she was the one being paid for her services. Nevertheless, because plaintiff alleges that defendant acted as a de facto agent of Mr. Peterson and or his team when making defamatory statements and undertaking tortious conduct, Mr. Peterson has a large role in this litigation. Thank you. Just as I was assuming. Therefore, some form of inference or jury instruction based on Mr. Peterson's refusal to answer relevant deposition questions may be appropriate. Further, Mr. Peterson's and his attorney's conduct justify sanctions, and plaintiff was prejudiced by their joint obstructive conduct during the deposition. Based on Mr. Peterson's refusal to testify, the court finds witness Daystar Peterson and his attorney, Crystal Morgan, in contempt of court on the following basis. A, Mr. Peterson's refusal to respond to the question of how he came to learn of or met defendant Cooper. B, Mr. Peterson's refusal to answer whether he has ever communicated with Ms. Cooper. C, Mr. Peterson's refusal to acknowledge purported communications with Ms. Cooper on Instagram and via text message. And D, Mr. Peterson's refusal to sit for deposition, including after being shown the entire exhibit binder that Ms. Pete's attorney intended to question him about. As a result of Mr. Peterson's deliberate evasion during 3 attempted depositions and his attorney's coordinated scheme with him to object, obstruct, coach, and deny the opportunity for questioning at his 3rd deposition, both Mr. Peterson and his attorney are hereby held in contempt of court. Therefore, for the foregoing reasons and the reasons stated on the record, witness Daystar Peterson and his attorney Crystal Morgan are held in contempt of court. Mr. Peterson shall pay to plaintiff's counsel the amount of $20,000 as a fine for his obstruction of plaintiff's multiple attempts to depose him, and attorney Morgan shall pay plaintiff's counsel the amount of $5,000 for her part in the obstruction and her failure to uphold professional standards. Now, I don't know where he found Miss Morgan. I don't know how successful she is in this field. So we'll see what the $5,000 does to her. But for him, he says he doesn't care about the 20. Okay? Furthermore, the undersigned recommends that the jury may be instructed that Mr. Peterson was properly asked the 3 questions listed above, but refused to answer and ultimately terminated the deposition without answering any questions. Ms. Lisette Reed, the judge, signs. Okay? Now, that also means that the jury in this Megan Thee Stallion versus Milagro case not only will be informed of Milagro's spoliation of evidence, aka deleting thousands of messages, deleting apps, not being forthcoming with her Discord information or logins to obtain records of her speaking on Megan, communications with Tory, communications with Tory's father and other people associated with Tory, with her trying to withhold that she was being paid. All these different things are going to be informed to the jury. Not only are those going to be told, but now the jury is also going to be informed of Tory Lanez evading the questions concerning Milagro, right? Because he was being asked how he knew her, how he came to know her, had he ever communicated with her in DMs or text messages, and he refused and put on a complete tantrum, right? Which is also going to be very fishy to the jury. So we saw we saw the exhibit list last night. There's fucking 40 plus pages of exhibits damning to Milagro in this. Not only are the jury going to be informed of that, but they're also going to know that both Milagro and Tory Lanez, the two people who are being accused of being in concert to create a harassment campaign against Megan Thee Stallion, were both being completely evasive, held in contempt, breaking the law in order to not produce, in her case, evidence, and for him, uh, confirming the relationship that he had, whatever the relationship was of their communication with Milagro. Okay? So I don't think this is going to be too good for Milagro. Now, TMZ put an update out this morning when they entered the courtroom. Let's see what TMZ had to say, because I thought this was pretty funny. So here TMZ says, we're told Megan arrived at court with 4 lawyers and a small army of legal assistants. She was wearing a houndstooth black and white outfit and tall heels and 2 diamond rings on one hand along with diamond earrings. Milagro, on the other hand, arrived with 3 attorneys. And while she and Megan did not look at each other one time, our sources say Milagro appeared nervous and fidgety. Milagro was draped in all black with cowskin style high heel slides and a gold bracelet to complete the look. Nervous and fidgety, they say. Okay? I can only imagine. Now, let's get to Megan Cuniff and the updates that she's provided thus far, which again, they've only been really in court for about an hour or so. Hopefully we have something of relevance to add here. But of course, the full length of updates are probably going to happen at a later time. So here we have Megan Cuniff's updates from the ground in Florida at the courthouse. All right, so this starts at 12:22 p.m. this afternoon. It says the jury has been seated for Megan Thee Stallion's defamation trial against Milagro Grrrls. 5 men and 4 women, including a black man and a black woman. The black man is a teacher who described himself as a disciplinarian. Opening statements began at 1:30 p.m. Here, it says Judge Altanega briefly summarized the case. Megan accuses Milagro of falsely accusing her committing the crime of perjury, of promoting a fake pornographic video of her, and of engaging in extreme and outrageous conduct by coordinating with Daystar Peterson, the man convicted of shooting Miss Pete. The judge said Milagro denies all allegations in any coordination with Peterson. She's a social media personality who reports on many topics in the hip-hop community, quote unquote. She acknowledges questioning Pete's credibility, and she maintains that any public criticism stems from Miss Pete's own actions and statements, not from Miss Cooper's conduct. Okay? So Milagro is maintaining that whatever the public believes about Megan has nothing to do with her, although she has influenced a lot of people. A lot of people tuned into Milagro's coverage of the Tory Lanez trial. A lot of people tune into Milagro for her perspective of the situation as it pertains to Megan ongoing since then. But that's their defense. Milagro's lawyer, Jeremy McLemont, mentioned one possible defense witness as Livingston Allen, a.k.a. the DJ that don't spin. A defense witness? Jurors already will be seeing excerpts from his video deposition. And of course, they're going to see how contentious that was. Side note, downtown Miami seems to have a real edge on. We don't give a fuck about that. The hell? Opening statements were about 45 minutes. Megan's lawyer played audio of the gunfire from Tory shooting her. then said Milagro saw the shots as her shot at the spotlight. Sheesh. Milagro's lawyer said she called Megan a liar because Megan lied. You got paid to say that? Oh, man, you finna be down for the count. Milagro is the first witness. Megan's lawyer, John O'Sullivan, is questioning her. He played audio of the gunshots and is asking her about what she heard. The jury saw Tory Lanez entire Cap music video, the one where he's chopping up the horse leg. And Milagro's tweet, Daystar, is that a horse's leg? O'Sullivan asked about Lanez being found in violation of his bail for witness intimidation because of the Cap video. Milagro says she doesn't remember. I could not say at this time, Milagro answered, and I can only imagine how many of those I don't remember, I can't recall, I cannot say at this time we're going to end up receiving in this testimony. Oh boy. Again, at this time, it's approximately 3:30 p.m. that I'm recording this video. Therefore, that's all the updates that I have from Megan on the ground. I'll probably have to come back at some point, do another video to get a recap of what happened today. But I was able to at least get into the contempt of Tory Lanez, the contempt of Tory Lanez's lawyer, the sanctions that have been imposed on both parties. We're able to get a little bit of a glimpse into Milagro's, questioning on the stand today. You see the nature of the answers. I don't think she's going to give too many answers outside of that context. I don't see how that's going to help her in any way, just not being able to remember, especially when being presented with fucking hundreds of exhibits actually showing her her actions, her words, her videos, her audios, her promotions of deep fakes, all of this stuff. The world's about to get dropped on her motherfucking head, in my opinion. But let me know yours down below in the comments. Be sure to like and share this video. If this is your first time seeing me on YouTube, go ahead and subscribe to the channel, become an insider. And I'll catch y'all on the next one, man. Y'all be good out there. Y'all be safe, and y'all watch y'all words. Mind y'all manners and shit like that, okay? Be cool. Yeah, family over fame in this bitch, yeah. The glory of living righteous is setting in. My street knowledge and education's a perfect blend. Young mogul, independent, I've been setting trends. The first one from my family to be faithfully wed. Fuck niggas and the horses that they riding on. I see this shit from all angles like a polygon. I'll never politic and the drama be piling on. Father and great son acknowledged like I'm Bobby Bonds. Conversation with my lady about the paper route. 5-6 bank accounts every day I make it count. They down talking my commentary for hating now. Well, I can take it cause I'm bodying your favorite now, please. I can do this shit in my sleep. I been writing for these niggas, y'all read it and weep. I been fighting these niggas if you speak on the street. I'll turn your birthday party into New Year's Eve. Don't let me take it there. We ain't playing fair. This the ATL, Southside nigga moving furniture like Wayfair. Life on hold, no insurance for your healthcare. Lifeline gone, so you wanna be a millionaire? Well, let me tell you about this world I built. The women I dodged, the niggas that I read for filth. The sympathy calls, consulting for the stacks I built. I had to